Let's talk about the verdict of the Presidential Election Petition Court. The court has delivered its judgment. The judgment did not go down well with many. Peter Obi disagrees with the court's reasoning, saying, "We disagree with the court's reasoning and conclusions in the judgment it delivered." According to Peter Obi, it is his intention as a presidential candidate and the intention of the Labour Party to challenge the judgment by way of appeal as allowed by the Constitution of the Federal Republic of Nigeria. Atiku says he takes great pains to tell Nigerians that the decision of the court of first instance on the election petition he submitted falls far short of his expectation. Using his words, "I refuse to accept the judgment because I believe that it is bereft of substantial justice." It is a continuation of the discourse. What were the grounds that defined the verdict of the court? One of such is electronic transmission of results. I have with me this morning Femi Aborisade, legal practitioner and human rights advocate. Comrade Aborisade, it's good to have you on State Affairs.
Eddie the Great, thanks so much for having me.
I'm happy to see you again.
Great seeing you.
One of the grounds that defines the judgment of the petition court is that the Independent National Electoral Commission, INEC, is at liberty to choose its method of transmitting results. What do you think?
Well, I think that is one of the grounds on which I disagree vehemently with the judgment of the Court of Appeal, which is the court of first instance as far as the presidential election is concerned. On pages 224 and 253 of the judgment, because I have taken time not just to read, but to download, print, and read. I have the collection here. The judgment held that it is not electronic transmission of election results is not mandatory. And I disagree. And I want to refer listeners to sections 47 sub 2 of the Electoral Act 2022, 62 sub 2, and 64 sub 6. These provisions expressly provide for electronic transmission of results from polling unit to polling unit at the polling unit, ward, local government, state, and national. In fact, Section 62 sub 2 provides for continuous compilation and updating of National Electronic Register of election results, polling unit by polling unit. And as far as Section 64 sub 6 is concerned, in the event of disputes, reliance should be placed on 1, the smart card reader, which was used to accredit and verify the voter, the data of accredited voters, and transmitted results from each polling unit. So, and I was expecting that the court would hold that the provisions of the Electoral Act are binding on INEC. And INEC itself, pursuant to the Electoral Act, which empowers it to prepare guidelines, put in place two systems: the BVAS bimodal voter accreditation system and the IREV, INEC results viewing portal, to upload and uphold scanned results of electronically transmitted results. So I do not agree with the Court of Appeal on that note. And if we cast our mind back to the Kenyan presidential election, it was decided within 14 days because the electoral law of Kenya provides for electronic voting, electronic transmission, and all the court did, as provided by the Act, is to ask that the Electoral Commission should bring all the materials, court officials, and the judge examined everything to determine compliance or non-compliance. And the court found and held that by virtue of the fraud involved in the process of transmission, the court nullified the presidential election. So I do not see the reason why the court of first instance in this matter would not be prepared to find and hold that electronic transmission, as provided in the Electoral Act 2022 and as provided and announced nationally and internationally by INEC, will not be binding on INEC. I think that is inexplicable to me.
The court affirms that INEC is independent and can therefore choose the method of transmission it deems fit, saying no law mandates INEC to collate results electronically. The court adds that failure to upload the photographic copies of polling unit results in real time did not invalidate the election. So Peter Obi and co. should be able to quote these sections at the Supreme Court.
I will expect their lawyers to rely on these sections. I will expect their lawyers to also rely on the pronouncements by INEC officials in the newspapers, social media, television houses, and video clips as if flying about.
Another point of dispute is that of Abuja. The court rules that residents of Abuja are not special. It says a candidate doesn't need to score 25% in FCT to become president, adding that the Constitution says 25% in 2/3 of 36 states. Did the Constitution not say and Abuja?
Well, that is another area that I vehemently disagree with the Court of Appeal in the judgment. However, I must say that for now, until the parties appeal and the appeal is determined, that is the law. But I disagree with that law. My own ordinary understanding of the provision of the Constitution is that a successful presidential candidate should have at least 25% of the votes in the Federal Capital Territory, Abuja. Permit me to read Section 134 2B of the Constitution. Permit me, please.
Please go ahead.
It says, and I quote, "A candidate for an election to the office of president shall, when we use the word shall in law, it means mandatory, obligatory, not discretionary, shall be deemed to have been duly elected where there being more than 2 candidates for the election, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the federation and the Federal Capital Territory." The key word here is each. Ordinary interpretation of Section 134 sub 2B of the Constitution says that a candidate to be declared as president should have in each of at least 2/3 of the states of the federation, not less than 2/3, not less than 25%, and the Federal Capital Territory.
What does that "and" mean?
I think that "and," when read along with each, means that the person should also, apart from having not less than 25% in not less than 2/3 of the states of the federation, the candidate should also have not less than 25% in the Federal Capital Territory, Abuja. Now, let me make it abundantly clear. I do not agree with the constitutional provision because it gives special status to residents
In Abuja.
in Abuja. And I think there should be equality of votes. But for as long as we have not amended the Constitution, ordinary interpretation means that a successful candidate as president of Nigeria ought to have not less than 25% in each of at least 2/3 of the states of the federation and the Federal Capital Territory.
Peter Obi and Atiku Abubakar are expected to file their appeal at the Supreme Court next week. If the Supreme Court affirms the decision of the petition court, it now becomes the law. In that case, do we need to still amend the Constitution?
If the Supreme Court affirms the position of the Court of Appeal, there will still be a need to amend the Constitution.
Would that be an indictment on the Supreme Court?
No, it's not an indictment. The Supreme Court will be deemed to have been interpreting the Constitution as it was then. Nothing stops the National Assembly, the legislature, from amending the Constitution to reflect the true intention. Even though I would not agree that the provision as it is should be there, that special status should be given to Abuja. But I know I was the founding general secretary of the National Conscience Party, of which the late Chief Ganifa Emi was the national chairman. I know that INEC does not register an organization as a political party unless that organization has an office
in Abuja.
Apart from having offices in not less than 2/3 of the states of the federation. That is the practice till today.
But in this case,
maybe political decision.
Interesting.
But it also tells me that perhaps we should amend the Electoral Act, Section 138 in particular, which provides that the person declared as winner of an election should remain in office until the petitions challenging the election are determined. I think we should amend the Electoral Act and or the Constitution to the effect that no one assumes office until all petitions are determined.
And that was what happened in Kenya recently.
Exactly.
William Ruto was not sworn in.
Exactly.
Until the Supreme Court ruled.
Exactly. Because if you have sworn in someone as president of Nigeria, who is in control of resources, and you now remove him, that could be chaos. And from the point of view of public good, in order to prevent chaos and not the rest, it is possible a court, just resolves a dispute to ensure peace rather than destruction. But if you have not assumed office, the court will be freer. You have sworn in a president who's already traveling about internationally, already recognized, who may also have an input in determining who is promoted from one court to another. We are all human beings. So I will advocate, and this is actually part of the recommendations of the Justice Waste Commission.
Yes. Who
advocated that elections should be brought forward so that petitions, are determined before swearing in. But they have not given effect to some of these recommendations.
Femi Aborisade is on State Affairs.